This program is brought to you by Emory University.
Okay, well, thank you. Good morning. My name is John Green. I'm the editor-in-chief of the Emory Bankruptcy Developments Journal. Thank you for coming to the 15th annual Emory Bankruptcy Developments Journal Symposium. First, I'd like to thank a few people. I'd like to thank our sponsors for helping make this event possible. Also, thanks to Professor Pardo for your guidance throughout the year and your constant support and dedication to making this journal better. I'd also like to thank our advisory board, in particular Mr. Mark Dudall from Bryan Cave, for always helping the journal and volunteering your time to help make us better. My final thanks is to EBDJ staff, all the students. Without each of your help today, this event wouldn't be happening. In particular, I'd like to thank Pat, Shira, Sam, and Rachel. Thanks for your help putting this on today. So this is our 15th year putting on a symposium. This is particularly impressive, I think, considering that each year a new staff of students takes over, knowing very little or nothing about bankruptcy, and plans and puts on this great event all about bankruptcy. So it just goes to show you the caliber of students we have in our journal and the quality of support we have from all of our stakeholders. This year in particular is very exciting for a number of reasons. This year is the first year we've had support from the American College of Bankruptcy, who you'll hear from shortly. We also had a great networking event last night, co-hosted by the International Women's Insolvency and Restructuring Confederation. Most importantly, I believe we have the best group of panelists this year that we've ever had, including presenters both from academia and from practice. A few administrative notes. Please make sure that you've checked in at the registration. This is particularly important if you're getting CLE credits today. We need to make sure we have all your information correct, and our staff will take care of what you need. We'll start the consumer panel shortly, followed by Q&A. At about 10:30, we'll take a break. Feel free to step out and enjoy refreshments. After that break, we'll begin the corporate panel, followed by another Q&A, and then lunch will follow after that. So again, thank you. With that, I'll turn it over to Dean Hughes to say a few words.
Good morning. My name is Jim Hughes, and I'm the interim dean here at the law school, and I'm really pleased to welcome you to the annual Emory Bankruptcy Developments Journal Symposium. And this is the 34th year of the Emory Development Journal and its 15th annual symposium. And next month, EBDJ will hold its 19th annual banquet, at which Judge Mary Walrath will be honored with a Distinguished Service Award for Lifetime Achievement. I should add that our bankruptcy program is a signature program here at the law school, and it provides a curriculum that truly integrates practice and theory and fosters close ties among scholars, students, judges, and practitioners. It's a model for legal education, we believe. For example, EBDJ students have served as clerks for bankruptcy judges and federal district court judges. Since 2009, 39 EBDJ students have served as clerks. From the class of 2017, 4 students secured clerkships. And from the class of 2018, 3 students have secured clerkships so far, and we expect that there will be more. Many students go on to practice bankruptcy and come back to the community to serve by serving on several of our alumni boards. In addition to having a large practitioner impact, EBDJ also strengthens our academic impact. EBDJ has had 3 articles featured in the Harvard Bankruptcy Roundtable, and since the last symposium, EBDJ articles have been cited 27 times in law review articles, 6 times by courts, including the Ninth Circuit and the Sixth Circuit, and the Connecticut State Supreme Court. Before we begin, I'd like to thank the many people who made today possible, our generous sponsors who are listed in your program, EBDJ advisors, Professors Rafael Pardo and Jim Elliott, EBDJ Alumni Advisor Keith Shapiro, Emory Law Class of 1983, and members of the EBDJ Advisory Board. Also, Executive Symposium Editor Pat Marr, Symposium Editor Sam Feldman, and Editor-in-Chief John Green, whom you've heard from earlier. Emory staff members Scott Andrews, Corky Gallo, Rhonda Hermans, Amy Marcellana, and Amy Tozer. And of course, our panelists who will enlighten us a little bit more later on today. Now, before we start with the panel, I'd like to introduce Eric Anderson and bring him to the podium. Eric is a fellow with the American College of Bankruptcy and chair of the college's 11th Circuit Educational Programs Committee and Law School Outreach Committee. He is a member of the Board of Directors of the Southeastern Bankruptcy Law Institute and a past member of the Board of Directors of Meritas, a worldwide law firm organization. Eric has also served on the Board of Directors of the Atlanta Bar Association and is a past chair of the Atlanta Bar Association Bankruptcy Section. Eric?
Thank you, Dean, and good morning. I am here today on behalf of the American College of Bankruptcy. We're kicking off what we hope will be a long and fruitful partnership with the Symposium. The American College of Bankruptcy is an honorary public service and association of bankruptcy and insolvency professionals who are invited to join as fellows based on a proven record of the highest standards of professionalism plus service to the profession and their communities. Together with our affiliated foundation, the college is actually the largest financial supporter of bankruptcy and insolvency-related pro bono legal services programs in the United States. The mission of the college is to honor and recognize the distinguished bankruptcy professionals who are qualified for membership in an effort to set standards of achievement for others in the insolvency community and to fund and assist projects that enhance the highest quality of bankruptcy practice, including undergraduate and graduate programs related to bankruptcy and insolvency. Among our many activities, the college conducts advanced educational programs, sponsors the publications of scholarly reports, and maintains the National Bankruptcy Archives at the University of Pennsylvania. In particular, our Educational Programs Committee, our goal is to fund and sponsor programs and to develop other programs designed to further and enhance those educational programs. We have conducted many programs in the 11th Circuit, but each year we would look around and try to figure out how we could add to the already impressive slate of educational programs in the community here in the 11th Circuit, and finally decided we can't beat the EBDJ Symposium, so why not join it? So we're hopeful that we can continue on a fruitful sponsorship. I want to now kick off and introduce the first panel on the consumer. To my immediate right is Pamela Fooey, an associate professor at the Indiana University's Moore School of Law. Professor, is it Fooey? Fooey, excuse me. Research centers on bankruptcy, commercial law, and consumer law. Her work primarily involves empirical studies of bankruptcy and related parts of the legal system, combining quantitative and qualitative interview-based research. She is also a co-investigator on the Consumer Bankruptcy Project, a long-term research project studying persons who file bankruptcy, which has been the leading empirical study of consumer bankruptcy in the past 35 years. Prior to joining the faculty, Professor Fooey was an assistant professor, a visiting assistant professor at the University of Illinois College of Law, clerk for the Honorable Thomas Ambro on the Third Circuit, and also worked as an associate with Dorsey and Whitney in Minneapolis. To Professor Fooey's right is Professor Cara Bruce, a professor and associate dean of faculty research and development at the University of Toledo College of Law. She teaches debtor-creditor law, business bankruptcy, secure transactions, and payment systems. Her research focuses on bankruptcy law and procedure, with a particular emphasis on private litigation and consumer bankruptcy cases. In the fall of 2013, Professor Bruce served as the Robert Zinman Scholar in Residence at the ABI in Arlington, Virginia. Then to Professor Bruce's right is Alex Sickler, an associate professor of law at the University of North Dakota School of Law, where she teaches contracts and commercial law courses, including bankruptcy and consumer finance law. Her scholarship focuses on consumer finance and bankruptcy laws, including as a co-author of a Bloomberg BNA treatise for counsel whose clients are subject to the jurisdiction of Consumer Financial Protection Bureau. Prior to joining the University of North Dakota Law School, Professor Sickler was a trial attorney at the Executive Office of the U.S. Trustee, litigating civil enforcement matters arising in consumer bankruptcy cases. And then the moderator of appearing on video later will be a fellow in the college, Professor Susan Block-Lieb, the Cooper Family Chair at in Urban Legal Issues, and she teaches bankruptcy, contracts, secure transactions, consumer protection, and other commercial law courses at Fordham Law. Professor Block-Lieb is a fellow in the American College of Bankruptcy and the International Insolvency Institute. And finally, our moderator is Austin Carter. Judge Carter has served as a bankruptcy judge for the Middle District of Georgia since May 2014 and handles cases in the district's Macon and Albany divisions. Prior to his appointment, Judge Carter was a partner in the Macon firm of Stone & Baxter, where his practice consisted primarily of business bankruptcy workouts, commercial litigation, and business transactions. Judge Carter.
Thank you, Eric, and thank you all. The way this is going to be structured, as I think you've probably already gathered, is we're going to have 3 separate presentations that are related and complementary, and we'll have one presentation. Professor Fowey is going to go first, and then we'll have a little discussion internally, and then followed by the next presentation with a little discussion, and then the next. And then at the end of all the discussions, then I'm told what we'd like to do is throw it open to general questions and answers with the audience. So unless there's something burning that must be addressed immediately, just hold the questions, and then we should have plenty of time at the end. All right, so thank you with that. Professor Fowey?
Great. All right, so first, thank you so much to the editors of the Emory Bankruptcy Developments Journal for inviting us to speak and for picking a topic that is so timely and important. Access to justice in consumer bankruptcy is actually a topic that's been around for decades, and scholars have focused on it for decades, but more research has been devoted in recent years to the issue because of advances in data collection, allowing for actual nationwide empirical studies, the effects of the Great Recession, the advent of the CFPB, and the rise of debt buyers and debt collectors. And how this range of topics fits together and combines with access to consumer bankruptcy, I think was really smoothly brought out in the 3 draft papers for the Symposium edition. And in fact, it was so smoothly brought out that I put it all together in a flowchart that both introduces what I'm going to talk about and brings the papers together, right? So when someone faces a money trouble, broadly, they can experience it either as an actual legal problem that it is, or it will remain illegal in their minds, meaning they don't think of it as something that they can use law to deal with it, right? So what they can do then is either negotiate, involve third parties to help them negotiate or otherwise help solve the problem, or just do nothing and stick their heads in the sand. Even if they view the problem as a legal problem, they still have the options of doing those 3 things. Just because you know something is legal doesn't mean you actually access law, either because you don't want to or you don't know how to. However, once they know it's legal, they can decide to bring some sort of other legal action, or they can file bankruptcy. And it's other legal action because obviously bankruptcy is most important here, right? Once they decide to file bankruptcy, they can choose Chapter 7 and Chapter 13. And within the bankruptcy case, they can bring those other legal actions in some instances, right? So given people's bargaining power, perhaps the most effective avenues to deal with creditors and vindicate their rights are to involve third parties and take some sort of legal action. And Professor Block-Lieb's contribution focuses primarily on how cities can help people deal with their financial problems by involving third parties and helping with legal actions. Whereas Professor Bruce's and Sickler's contribution focuses on other legal actions within bankruptcy, specifically in the context of debt collection. Now, my contribution focuses on research and what we know about how people get from money trouble to filing either Chapter 7 or Chapter 13. And in tracing the journey that people take through the paper and in my talk, based on what we know, I have 3 goals for the next about 15 minutes. I want to overview what we know based on actual empirical research about people's steps. And then I want to add a little bit of new data about how people get from money trouble through legal problem to bankruptcy. Right? And then based on the foregoing, suggest where we need to turn next. And there's really 2 steps here. There's money trouble to bankruptcy, and then there's bankruptcy to Chapter 7 and 13. And as you'll see, I think we know bankruptcy to Chapter 7 and 13 enough to move on, and we need more research as to the steps. Right? So starting at the top, money trouble to legal problem. Right? And thinking about access to bankruptcy, the first question really is, do people understand that their financial problem is a legal problem? And only when they think it's a legal problem, even if they know the word law or bankruptcy, will they think about law and bankruptcy. And research generally shows that most people don't see the overlap between problems in their lives and judiciable events as actual civil justice problems, right? So they never turn to law. And importantly, this research shows that lack of money, although sort of important, is not necessary or primary to the step from I have a problem to this is a legal problem. It's really about social construction, talking to neighbors and thinking about what is happening in your life. In the context of bankruptcy, there is very little research about how people get from money trouble to legal problem to even filing bankruptcy. And this partially is because it's very hard to get data on people who have not filed bankruptcy, right? Most of the data in terms of what is accessible is people's bankruptcy cases. And thereby, the bulk of the research that can be brought to this question comes from the Consumer Bankruptcy Project, which, as was brought up, is a long-term study of the people who file bankruptcy. It was started in the 1980s, and I am a current co-investigator on the current iteration, which includes people who filed from 2013 to 2016. My co-investigators now are Bob Lawless from the University of Illinois, Katie Porter from Irvine Law, and Deb Thorne, who's a sociologist and an anthropologist at University of Idaho. And what we do is we pull court records, and we also send a questionnaire to debtors asking them about their journeys to bankruptcy and other things like that. So on this issue of money trouble to legal problem, perhaps the best data we have are debtors' responses to the initial question of how long they seriously struggled to pay their debts before they filed. Right? And as you can see on this graph, which is from a forthcoming paper, 2/3 of debtors now say that they struggle for at least 2 years before they file bankruptcy. And this is the black lines on the bottom, which is the current Consumer Bankruptcy Project. And almost a third, say that they struggle for more than 5 years. The light gray lines are lines from the 2007, or data from the 2007 Consumer Bankruptcy Project, which asked the exact same question. And as you can see, the percentage of debtors saying that they struggled a long time has risen since 2007. What's important about this graph for the purposes of question of access to bankruptcy and how people get from money trouble to law is that we also asked debtors what they did during the years that they struggled before they filed for bankruptcy. What did they go without? What actions did they try to take to pay their debts? And people report that they went without necessities like food, utilities, and healthcare, and also that they tried to negotiate with their creditors, they sold property. They essentially did everything that research shows that people do who don't turn to law, either because they don't want to or they haven't thought about law yet, right? And why debtors are filing so long, we think connects with their answer to why they ended up filing bankruptcy. Debtors overwhelmingly cite pressure from debt collectors as a trigger of their actual filing bankruptcy, right? Figuring out that bankruptcy is a solution. 75% cite pressure from debt collectors. And many of these debtors also had their creditors file actual state law collection actions against them, as well as attach liens to their homes. And this goes with social construction, right? Their creditors are telling them that they actually have a legal problem by either calling them and saying, pay me now or I'm going to take you to court, or actually taking to court. And then that triggers, oh, this is an actual legal problem, maybe I should find out something about it, and brings them to the legal system. Which leads to the next question, right? Going back to this. Question 2 is, a person knows that their problem is legal. How do they pick bankruptcy in particular and don't go down the other legal avenue route? There's even less research than this, and there wasn't much about the first question, right? There's a couple of studies about social spillover, and there are quantitative data studies that show that if a zip code area has an increase in consumer bankruptcy filings in a particular year, in the next year, there's likely to be a bigger increase in consumer bankruptcy filings, suggesting some sort of talking between people about the legal option of bankruptcy. But perhaps the best data we have is actually a study I did of pastors and other leaders of religious institutions that put their churches into Chapter 11. And it's the only study I know of where debtors were asked directly, why did you pick bankruptcy out of everything you could have done? And then I previously asked them, how'd you figure out you could do something legal to begin with? Their answers are relevant because church bankruptcy filings track fluctuations in consumer bankruptcy filings, not business bankruptcy filings. So these are essentially people filing for bankruptcy but using Chapter 11 because they have a corporate structure. And also what the pastors told me, track research about people's feelings when they file bankruptcy. And what the pastors told me is key to these 2 steps. First, they told me that their creditors pushed them to think about their problems as legal by filing foreclosure actions against them, or actually saying to them on the phone, why don't you think about filing bankruptcy? And second, they then turned to their social networks to connect the newfound legal problems with bankruptcy specifically, right? Which suggests that people come to bankruptcy in a way that tracks all the other research about how people come to law generally, and that can be brought to bear on these questions. Nonetheless, it leaves huge questions, such as, what about all the people who don't file bankruptcy? What do they do? Do they stick their heads in the sand? Does it get worse? Or are they able to figure out something with their creditors such that they regain their financial footing? And data to address these questions is very hard to come by, and I'm going to push to say it's something we should try to come by more often. There is a new data source, which is relatively recent, which is the Consumer Complaint Database maintained by the Consumer Financial Protection Bureau. And this is a snapshot of the current CFPB page where you can get the complaint database. I chose this snapshot because the CFPB's website has been revamped recently, and what was a lovely interface has turned into a lot of words on a page, and this was the best picture I could find. Right? So in prior work, what I did was to analyze a random sample of 6,000 of these complaints that had narratives. So consumers actually wrote to the CFPB and had 200, 300 words about their problem. And my goal with that was to assess how people voiced their complaints, right, to see how they were coming first from money trouble to maybe a legal problem, and then how that fit in with the role of the complaint mechanism and if people understood where the CFPB fit in that process. For the purposes of this talk and the paper, I also coded the narratives for mentions of bankruptcy. And it didn't fit in with the prior work, and so I get to use it now. And I think it's really important to look at the narratives here because there's very little data about how people think about their legal problems, money problems, absent being prompted with the word bankruptcy. Right? So do people bring up bankruptcy when they talk about their financial problems otherwise? And this data can show us this. So 4% of the sample narratives mention bankruptcy. That might not seem like a lot, But if you think about the fact that the CFPB has processed over 1 million complaints since it opened the database, that's over 40,000 consumers saying bankruptcy unprompted to the CFPB when talking about their money troubles. Most of those people talk about debt collection and credit reporting post-bankruptcy discharge. Say, my credit reporting agency won't take it off my credit report and I think it should be off, right? Or someone's trying to collect on this debt. But 15% of those 4,000 narratives, which you sort of have to add more to since it's a sample, talk about bankruptcy as part of the story of financial collapse, from a money trouble through life troubles, through law, and then into bankruptcy. They are essentially creating my flowchart, right? For instance, right, this is what a narrative on the database looks like. And I had to pull this picture because if you click on the consumer complaint narratives at the bottom here with the 3 little dots, the whole website now blows up. So I had to pick carefully. This isn't the best, but if you read what this consumer is saying, they discuss a problem, a struggle, medical problems, medical debt, then having to file for bankruptcy, though they worked for years to try to avoid it. So I don't want to oversell or undersell the narratives here. But where there is little data, these narratives lend credence to the benefits of continuing to study how people end up filing for bankruptcy or deciding to file for bankruptcy. And the research is useful not only to assess how they come into the system and their access to the system, but also the role of law and legal institutions in effectuating people's rights. And more access to law is actually not necessarily more productive, which is weird for a lawyer to be saying. But there is a point that if law is not brought to bear in those third-party interactions, the force of law may decrease, which would be not beneficial overall, or only certain people can take advantage of their legal rights. And you don't know the answer to the balance until you really get into what people are thinking. So these are necessarily big questions to evaluate the first couple steps to access to bankruptcy. Okay, so that's step 1. Step 2 is, hey, people know they are going to file bankruptcy. They go to an attorney to file. Can they actually access bankruptcy as a legal and financial matter? And despite the 2005 amendments, the crux of this step still remains chapter choice, chapter 7 or chapter 13. And this is a critical decision, and I know everyone in the audience knows it's a critical decision. Unlike step 1, this step has been well researched. This map on the slide depicts the enduring regional disparities in the proportion of households in different districts that filed Chapter 7 versus Chapter 13. Right? The map is based on data from 2014 to 2015, which is in the middle of the current consumer bankruptcy project. I could have had this map on the board from 1980s onward, and it would look basically the same. Right? And what leads to the map has been termed local legal culture. In addition to this, regardless of where a household lives on the map, if that household is Black, it is more likely to file Chapter 13 as compared to similarly situated other households in that district. Right? So if you're Black, you file Chapter 13 more often. Now, to explore what might influence this racial disparity, not the regional disparity, Jean Brocker, Dub Cohen, and my co-author Bob Lawless, in a now consumer bankruptcy world famous study, I think, sent consumer bankruptcy attorneys from across the country's vignette of a couple seeking filing advice. The couple had a mix of financial characteristics that made Chapter 7 or Chapter 13 a toss-up, and the author varied the couple's names to be Reggie and Letitia versus Todd and Allison versus no names, and then whether the couple told the attorney that they were thinking and leaning toward Chapter 7 or Chapter 13. The upshot of the study is that attorneys were twice as likely to recommend Chapter 13 for Reggie and Letitia as for Todd and Allison. And then when asked about their chapter choice, they thought Reggie and Letitia had effectively good values if they wanted Chapter 13, whereas Todd and Allison had good values if they wanted Chapter 7 and needed to be corrected for their financial miscalculation if they wanted Chapter 13. Now, note that the authors never said that attorneys knew they were contributing or seemed to be contributing to the disparity. This is really about implicit bias, and I point you to Professor Michelle Dickerson's work about implicit bias in bankruptcy. But they never said that attorneys know. In fact, Lawless, Cohen, and another co-author, Fei Shin, sent a survey to consumer bankruptcy attorneys across the country before they did the vignette study and asked them what they thought about the disparity. So it was like a pre-study to the study they actually were going to publish. And attorneys indicated that they thought more white households filed Chapter 13 than black households across the country. And those co-authors recently published the paper. It's called Opposite of Correct, right? And kind of fits it all together. So now, this is where attorneys' fees fit in, and money actually becomes important. Right? Attorneys necessarily have to charge more to file and assist with a Chapter 13 case than Chapter 7 case. Also, because of the code, attorneys basically require their debtors to pay Chapter 7 fees up front, whereas Chapter 13 fees can be paid during the plan, leading to the 3 ways to pay that are on this slide and 3 ways to file. You have a Chapter 7, and these are attorneys' fees in 2015 dollars from the Consumer Bankruptcy Project. You have what we call no money down Chapter 13, where debtors pay $0 in attorney's fees up front. And we have what we call traditional Chapter 13, which is when debtors pay at least $1 in attorney's fees up front. Right? And we wrote an article about no money down Chapter 13 because we saw that the financials of the people who filed no money down Chapter 13s looked more like Chapter 7 debtors than the traditional Chapter 13 debtors. So we wondered what was going on here. And we found that there are 2 factors that determine whether a household will file a no money down Chapter 13 case. I bet you can tell me what they are, right? Where they live and the household's race. So what this graph shows is Chapter 7, the dark lines, no money down Chapter 13, the kind of deep blue lines, and traditional Chapter 13, the light blue lines, broken down by the household demographics. And you can see that black households are much less likely to file Chapter 7, which we already knew, and more likely to file a no money down Chapter 13, even as a percentage of the Chapter 13 cases that they file. So at this point, what you do is you run a regression to see if you can explain away both the location and the race disparities. And the answer is you can't. And so what we did is after we ran the regression and realized that location and race are still the biggest predictors of filing a no money down Chapter 13 case, is we created a handy graph that is hard to read, but the best we could come up with, to show what is going on with no money down Chapter 13 and how it fits in regional and with racial disparities in bankruptcy filings. So what you have here is the results of the regression used to predict the probability that a household in a given district is going to file Chapter 7, no money down, or traditional Chapter 13, based on the percentage of Chapter 13 cases baseline in that district. Right, so the y-axis is the probability, the x-axis is the Chapter 13 rate in the district, starting on the left with the low Chapter 13 districts, right, 10% are Chapter 13, and moving all the way to the districts in which 80% of the cases are Chapter 13. And then we have 3 lines, right, one's Chapter 7, one's no money down, and one is traditional, disaggregated by black households and all other races. And the X's, the lines with the X's are Black households. The line with the dots are all other households. The top two lines is the Chapter 7 filing rate in the district. The lines with the X's should be lower than the lines with the dots because Black households are less likely overall to file Chapter 7, and we reproved it with new data. Right? The bottom four lines are the Chapter 13 filing rates disaggregated by traditional and no money down. And what you can see is that as you move across districts to high Chapter 13 districts, the red lines converge, and that is traditional Chapter 13s, where by the time you get to a place like Alabama, people are filing traditional Chapter 13, not disaggregated by race, at the same percentages. And the entire difference in Chapter 13 filings is made up by no money down bankruptcy cases. So bringing together both district and race. Since we came out with this study, there's been a couple more studies that have provided additional confirmation for the apparent role of really legal professionals in both the racial and probably regional disparities. One's in ProPublica, I think it was pretty prominent, and one is going to come out in Texas Law Review, which was done by Bob Wallace, my co-author, and Angela Litwin, who is a professor at Texas Law. Which leads to, in my view, not calls for more studies, although more studies are great because I love data, please replicate, but tactics to incentivize system actors, attorneys, trustees, and judges to assess the system that they operate in and their actions within the system. As such, my last slide, and this is the last one, is suggestions. Some of these suggestions are vastly more realistic than others, and I recognize that. But for the purpose of having suggestions, I just threw them all up on the slide. The ones that I think are really important now is to encourage actors to track their clients and cases. And there's ways to do this, such as involving things like best case, and actually have downloadable data for people to see easily. You don't have to do it yourself. And then more judicial oversight over Chapter 13 fees and plans. Right? Don't kick people out of Chapter 13, but if it looks like Chapter 7 is better for them, it's gonna be less expensive, and they're gonna get discharged sooner if you just flip them to Chapter 7. So I'll stop there and tee up mini question section.
Thank you, Professor Foey. That was very interesting. Let me, the last thing anybody wants today is a political discussion, but you mentioned the CFPB and the complaint process. Is that going to continue in your estimation with the change of leadership at the helm of that organization?
Yeah, that's a great question. For the purposes of the paper, I just used the data to show something about people's thought processes. The previous paper I wrote, I actually had suggestions for the CFPB and other state and federal agencies about how they could use their narratives to help people. In terms of the CFPB, I actually had discussions with the complaint office, and they were going to implement the changes, and they said it could be done, and it could be done better because they had even more data that's not public. I doubt that's going to happen now, but that doesn't mean that other agencies can't do the same things with their complaint database, and I would hope that some states would take over the CFPB while it's in its temporary holding downward spiral pattern.
All right, that's a diplomatic answer. As far as the Chapter 13 versus Chapter 7, some of those statistics were stark, and I can tell you, in my world, that subject's getting more and more attention at the Federal Judicial Center seminars each year. They give CLEs basically for judges, and on this year's agenda is a discussion of race and Chapter 13 versus Chapter 7. Is there data to show, though, that you mentioned the Lamy decision from the U.S. Supreme Court that put in jeopardy the ability of a lawyer to collect Chapter 7 fees after the case is filed? Did that cause a spike, or is there data to show whether that contributed to this Chapter 13 phenomenon?
That's a great question. So based on the data, that nationwide data that's been studying, the decision came before there were big studies because of data collection problems. So it's, I mean, the No Money Down Chapter 13 has been around for as long as the racial aspects of Chapter 7 versus Chapter 13 have been known. So I don't think there's enough data to answer that question. However, it's a problem, and we've been studying it since 15 plus years, and it's not budging based on our data. So I think it's now time to turn to FJC and stuff like that.
Well, there are some, there's not many, and I don't begrudge lawyers for not wanting to venture into the waters, but there are a handful of decisions, I believe, around the country that give some room for the idea that there can be a Chapter 7 with fees paid post-petition not subject to discharge. But lawyers are naturally risk-averse, and unless there's a lot of case law, you're probably not going to get many venturing into that area.
I mean, this is an easily fixable, in terms of actual statute, problem. I think there would be bipartisan support for fixing what looks like an oversight. Whether that will happen, I don't know. But if you ever want to go hard on a statutory change to the code that I don't think anyone would push back on, this is where to go.
Logically, that it makes eminent sense. The trick is figuring out the key to make Congress act.
Shove it in the venue statute.
The no money down cases, are there lawyers, as far as you know, everywhere that offer that, or is that really offered only in the districts that have the high Chapter 13 cases?
So based on our data, it's lawyers everywhere. And so we were able to control for it across districts, right? So if you go back to this slide, there's no money down going on in a district in which only 10% are Chapter 13. It's more prominent in places where there's more Chapter 13 cases, and disproportionately more prominent, right? And it also seems to be operating differently in districts in which there are a greater Black population to begin with, and just a higher Chapter 13 rate. So it's everywhere, and in the paper we say it's not just Black households, it's every household, and every district should be examining what's going on with their dockets.
And most of those cases, I'm sure you're aware, end up being, well, most of the no money down cases, or many of them, are no asset cases. And that's been sort of a complementary area of hot discussion among the judges and bar in recent years, which is these basically fee-only Chapter 13 cases. And I can't give you specifics about other districts. I know it's controversial, but in the 11th Circuit, there's an 11th Circuit opinion on these fee-only cases, and it affirmed the bankruptcy court's denial of confirmation based on a lack of good faith, but it said we're not setting a hard and fast rule. You have to look at every case. It left the door open that under some circumstances, a fee-only Chapter 13 case is okay.
Yeah, so I think fee-only cases are part of the problem. We created a variable for fee-only cases that we fed into the regression, and we went through the case law and said, is this district strict about them, less strict? And it's not an explanatory variable at all, and so we actually just sort of threw it out. It does nothing. So there's a question in the audience, and I know we have, not to push you, but yeah. Yeah. Household income was a control variable for whether that explained any of the disparities on either basis, and the answer is no, as it hasn't for 20 years. Yeah.
Well, how would you respond to, one of the things I've heard over the years is as to a rationale of why the southern states have such a higher Chapter 13 filing versus other states, is that the southern states tend to be harsher about, on a state law basis, wage garnishment. Is that a viable argument or rationale for higher Chapter 13s in those districts?
So it's not viable, in my view, on two bases. So first, Indiana, where I'm from, has some of the harshest wage garnishments in the country, laws. And it's not a high Chapter 13 district. There's really no difference between here and Indiana on that basis. And then when you look at this map, there's states that have multiple districts, and they have relatively vastly different Chapter 13 rates. And so if it was something like a wage garnishment law driving the high Chapter 13, why is it different within the same state? It's really local legal culture, and legal is the word of importance with those three words.
And the last thing I will ask you is, I think I know your answer to this, but it'll be interesting to read your forthcoming article about the sweatbox, I think you called it.
Life in the sweatbox.
If you read the literature back when Congress in 2005 was passing BAP CPA, you would believe that there's a large percentage of debtors that are intent on abusing the system, and your research seems to suggest that's not such a high percentage.
Exactly. So that is one of the main conclusions of the paper. And the sweatbox has been around for a long time, but we use the debates around BAP-CPA and this idea of bankruptcies of convenience filed with little disregard for the stigma of getting into debt and filing as a frame to say it's just not true. We knew it wasn't true in 2005, and by the way, it's still not true. And the bankruptcy system is based on this view and thereby can't actually give people the financial fresh start that it thinks it's giving because its entire theoretical basis is a little off. Thank you.
Well, thank you. Again, that topic is fascinating and a little troubling, and I think we're all going to hear more about it in the future than less. So thank you. And next we will hear from Professors Bruce and Sickler.
Good morning, everyone. I want to, it makes me look more official to have some, nice graph behind me. I want to echo Pamela's thanks to the Journal for putting on this great symposium, all of you for being here. I'm going to pick up where Pamela left off, talking about access to justice along the path to bankruptcy, and talk about access to justice for consumers who are in the midst of a pending bankruptcy case. For the last several years, my research has focused on how the bankruptcy system can break down if certain parties, and I focus on creditors, bend the rules or break the rules outright. And I have explored whether individual debtors or acting collectively, whether debtors individually or collectively, can play a larger role in either vindicating their own rights or preserving the integrity of the bankruptcy process by bringing private lawsuits for damages. So today what I'm going to do with my portion of our time is talk briefly about a trend in litigation that will be familiar to some of you. It got its start here in the 11th Circuit with a case called Crawford versus LV&V, met its end in the Supreme Court last May, and I'll talk about that in a second. I'm going to talk about this trend of litigation and use it as a case study to challenge some of the assumptions I've made about using private litigation in bankruptcy. And then I'll hand the mic over to my co-author, Alex, who's going to think a little bit more about the issue that the Midland Funding case presents, and how the bankruptcy system is trying to respond. So I assume many of you in practice are familiar with these cases, or maybe you attended the symposium 2 years ago where some of the litigants involved in these cases were presenters. But for those of you who are unfamiliar, I'll start with the problem of stale debt claims that really inspired this area of litigation. So the trend that emerged over the last decade or a little bit more is that debt buyers, commercial debt purchasers, would purchase large portfolios of debt for pennies on the dollar and file proofs of claim for debt, some of which the statute of limitations had run. So they're filing proofs of claim on old debt. And if the statute of limitations has indeed run, that presents a grounds for objection. And if someone objects, the claim will be withdrawn or ultimately disallowed. But what has happened in consumer cases is that not all of these proofs of claim are caught. And if they're not caught, based on the prima facie validity of claims, if they're not caught, the claims are allowed, and the creditors who file these time-barred debt claims will receive a portion of the debtor's plan payments or distribution from a Chapter 7 case. So this problem of stale debt claims falls pretty easily within something I've described as consumer bankruptcy's enforcement gap. I start, when I think about an enforcement gap in bankruptcy, from the idea that consumer bankruptcy functions on economies of scale. We have to keep access to the bankruptcy forum relatively affordable for debtors. And the way that we accomplish that is most bankruptcy professionals who work in the consumer world have very, very high caseloads. And so you can point to areas in the bankruptcy code and procedural rules that sort of facilitate a reflexive approach to consumer bankruptcy cases. Attorneys don't have to sort of move the case forward. In a lot of cases, it's designed to function automatically, and it's only if somebody raises the flag that there's a problem that we sort of put the brakes on and resolve that issue. So when you see people filing stale debt claims, that doesn't violate the bankruptcy code or procedural rules, but it takes advantage of a gap, gaps in the system that people maybe not catching all the stale claims that are filed, either because their workloads are too high, there's just too many claims clogging up the system, or it's difficult in some cases to determine whether or not the statute of limitations has run. So we have this enforcement problem with respect to stale debt claims, and the FDCPA has stepped in over the last several years to present a potential solution. So this is a legal theory that got its start in Alabama, and as I said, made its way up to the 11th Circuit. And the argument was that if a debt buyer files a proof of claim, knowing that it's time barred, that's false, deceptive, misleading, or unfair and unconscionable conduct under the Fair Debt Collection Practices Act. And the 11th Circuit agreed with that assessment in a case called Crawford versus LVNV Funding, which was decided in 2014. That spawned a flurry of litigation across the country where people were bringing similar suits based on the filing of stale debt claims. As these cases moved through lower courts and up through the appellate courts, we saw splits develop on a variety of issues. Probably the biggest issue that emerged is the extent to which the FDCPA can even apply in bankruptcy. Should it be allowed to sort of lay over the bankruptcy code's regulatory scheme and punish proof of claim conduct? So that was an issue that came back before the 11th Circuit in a case called Johnson versus Midland Funding. In that case, the 11th Circuit held that, yeah, the FDCPA can augment bankruptcy's claims allowance process, and then they looked back to the Crawford decision from 2014 to find, and in this context, with the filing of a stale debt claim, the FDCPA was violated. So that's the case on which the Supreme Court granted certiorari, and last May, in Midland Funding versus Johnson, the Supreme Court didn't decide the issue of the intersection between the bankruptcy code and the FDCPA, but instead rejected Crawford, found that if you file a time-barred debt claim without some sort of affirmative misstatement or other violation, that a mere filing of a time-barred debt claim does not violate the Fair Debt Collection Practices Act. And I'll just footnote at this point that that was one of two major FDCPA decisions to come out of the court last year. There's another case called Henson versus Santander Consumer USA. That one has the potential to have even broader impact on FDCPA litigation because it suggested that debt buyers, your Midland Fundings, your LVNVs, may not even qualify as debt collectors under the FDCPA. So we have this decision in Midland Funding, and I'll just take a moment here to think a little bit about the holding of the case, and then I'm going to step back and talk about access to justice. So I think the Midland Funding case is notable because the Supreme Court was very confident in the ability of the Bankruptcy Code to police this process on its own. They focus particularly on the presence of Chapter 13 trustees who can spot stale claims and deal with them. Also the fact that many debtors are represented by counsel in Chapter 13 bankruptcy cases, and they looked at the Bankruptcy Code's procedural structure. We also saw in the oral arguments of these cases, Justice Breyer, who ended up writing the opinion, was very sort of preoccupied with the idea that the FDCPA would overregulate, would sort of pile on to existing remedies that could already address this problem. And so in Alex's talk, she's going to sort of push back against some of those assumptions and paint a picture of the bankruptcy system after Midland that we believe, from talking to trustees and looking at case law, is struggling to address this issue without the benefit of the FTCPA. So that's about all I'll say on the court's ruling. And we can talk more offline. I've got lots more to say about it. But I want to spend just a little bit of my remaining time on private litigation. What can we see in this arc? So 2014 to 2017, ton of FTCPA cases coming through the bankruptcy courts and up through courts of appeals. What does that tell us about how effective private litigation is in preserving the integrity of the bankruptcy system or achieving access to justice? So I'm going to start using a theoretical lens. And if you look at it theoretically, you can make a really, I'm going to try to make a compelling case that this spate of lawsuits functioned exactly like private litigation should. We had a regulatory gap. We had things that were slipping through the cracks, and debtors and their attorneys leveraged the FTCPA, its litigation incentives, to bridge that gap, to address new conduct that had arisen. So here we see the FTCPA acting very nimbly and quickly to deal with an emerging problem. We didn't have to invest public resources in addressing the problem. We didn't have to engage in complicated law reform. We didn't have to lean more forcefully on trustees, which, ultimately, the more trustees have to police this, the less, those costs can trickle down to creditors who have complied with the bankruptcy laws. And we didn't have to do any of that using the FTCPA. It also centralized recourse in the hands of debtors. And debtors, at least compared to case trustees, arguably have better information about whether or not the statute of limitations has run. So all of that, I think, paints a positive case that private litigation did what it's supposed to do. Now, if you're inclined to think that private litigation is bad, you can make a negative case as well. It's hard to get around the fact that outside of the 11th Circuit, these cases failed at a pretty high rate. Not many courts adopted the Crawford rationale that this violated the Fair Debt Collection Practices Act. And yet a lot of courts were really burdened for a couple years dealing with those legal issues. So that can feed a critique that private litigation is messy, it's inefficient, and even that profit-motivated attorneys are going to push the law in directions it should not be pushed. So you can look at this from a negative angle as well. From an empirical perspective, I think there are a lot of unanswered questions. I'm going to assume, and I think we could spend some more time challenging this assumption, but I'm going to assume that the goal of these cases was deterring debt buyers from filing stale claims. And we've heard some anecdotal evidence that maybe the Crawford case did that. In fact, at the last symposium in 2016 that you all put on, the litigants suggested that creditor behavior, at least in the 11th Circuit, had changed as a result of Crawford. So big questions, whether that extended beyond the 11th Circuit, what we're going to see now that Midland effectively sanctions the filing of time-barred claims. These are all questions that if we dig into the claims registers, we may have answers for. I don't think we have answers for them right now. So where do I come out on this at the end of the day? I do think that there is one overriding functional benefit of these lawsuits in achieving access to justice, and that one overriding benefit has to do with awareness. So if you were in practice, say 10 years ago, did you know that stale claims were an issue? If you worked in the consumer world, you might ask yourself if this was something that you were aware of. It was happening. The Bankruptcy Rules Advisory Committee was dealing with it as early as 2009. But then ask yourself now in 2017, is this something that you're more familiar with? I think many of us would agree that our knowledge of the problem of stale debt claims has expanded dramatically in the last several years. And so to the extent that that primes the bankruptcy system to respond, and response here can be a lot of things. It could be in individual cases, debtors counsel and case trustees taking on more of a case-by-case review and objection of claims. It could be at the U.S. trustee and courts levels with judges setting local rules and standing orders saying, this is part of your job responsibility, or the U.S. trustee program issuing guidance to individual trustees saying, yes, you have to do this. It could also go to a higher level through bankruptcy rule reform, law reform, or other administrative action. So to the extent that we have these changes, and we have seen the bankruptcy system respond, whether on the ground or ultimately on a more systemic basis, I think that we can say that these lawsuits did contribute to access to justice just by raising awareness of these problems and charting out some of the issues that are happening. So I will leave it there and pass the mic over to my co-author, Alex. Thank you.
Good morning. Like my co-panelists, I'd like to thank the Journal for the opportunity to be here and your hospitality, and thanks to all of you for being here in attendance as well. So Kara just spoke more broadly about the role of private litigation and access to justice in bankruptcy. And she looked at access to justice through the lens of FDCPA litigation over the filing of stale debt claims in bankruptcy. And that backwards look at Midland Funding highlights another broader access to justice point, which is that where access to a private remedy has been cut off or found to be non-existent, we should consider looking to public law solutions to fill the gap and to remedy a practice that harms consumers and the bankruptcy system as a whole. So what I'd like to talk about is how the consumer bankruptcy process is still searching post-Midland Funding for a way to eradicate the practice of filing time-barred debt claims in a way that doesn't overburden the system, and also talk about possible public law solutions that would target the filing of time-barred debt claims as a business strategy or a business practice. And I'd like to start by talking about some of the issues we see in the Midland Funding decision. As Kara noted, that decision makes detection and disallowance of stale debt claims a case-by-case process that relies on the presence of case trustees to police these claims. And while case-by-case review and objection certainly reaches time-barred debt within an individual case, this solution may not be ideal for a few reasons. First, that solution fails to target the filing of time-barred debt claims as a business practice that exploits and imposes costs on the bankruptcy system as a whole. Remember that debt buyers file stale debt claims as a business strategy, hoping that a certain number of these claims will pass through the system undetected and be profitable. So we have a situation where these claims are more profitable in bankruptcy than outside of it, right? Second, case-by-case review results really only in the disallowance of the stale debt claim and isn't accompanied by the threat of a more substantial penalty that would deter the practice. And finally, Midland Funding relies on the presence of a knowledgeable trustee as an adequate source of objections to stale debt claims. But it's not entirely clear that assigning the role of gatekeeper to trustees comports with the code or the realities of Chapter 13 practice. And I'll talk more about that shortly. But first, I'd like to talk about how debtors and how the U.S. trustee program has tried to target the practice of filing stale debt claims through means other than FDCPA litigation. First, debtors have asserted a variety of legal theories to challenge these claims, both in an individual capacity and on behalf of a putative class. They have alleged that the filing of these claims as a practice is sanctionable under Rule 9011, that it is an abusive process punishable by the court's inherent or statutory contempt powers, or a fraud on the courts. And all of these strategies have been unsuccessful, with the courts almost uniformly saying that the code permits the filing of a claim for time-barred debt and provides a mechanism for disallowing it. The U.S. trustee program, for its part, has also been unsuccessful in litigation, challenging the practice of filing stale debt claims. In a case that was pending while Midland Funding was on appeal, the U.S. trustee sought sanctions and other remedies against a few debt buyers for their, quote, systemic abuse of the bankruptcy process by the filing of time-barred debt claims. And in that case as well, the bankruptcy court declined to sanction the debt buyers under either Rule 9011 or Section 105. So in the wake of Midland Funding and its unsuccessful litigation strategy, and some of these other failed tools, what we see the program doing is also looking to trustees to address stale debt claims. The program's executive director, has said that he expects trustees who are already objecting to stale debt claims to continue to do so. He has expressed his aspiration that trustees engage in a rigorous review of claims policing for stale debt claims, and he has also noted that the program is considering issuing formal guidance for trustees on this topic. And so what all this means is that, at least right now, this issue is left to case-by-case review and objection, with the case trustee as the primary gatekeeper. And the result that there isn't really a good tool, at least not one with a threat of a penalty, to deter stale debt claims from continuing to exploit the system, okay? But there are issues with relying on case trustees. That is part of our ongoing research. So first, we question whether allocating this burden to the trustee is in tension with trustee duties under the code. Section 704A requires trustees to examine proofs of claim and object to the allowance of any claim that is improper, but only if a purpose would be served by doing so. The code does not explain when a purpose would be served by objecting, but this language is generally understood to be driven by economics. What we mean is that trustees have a duty to object when other creditors would receive a greater distribution if the claim's objections were pursued and successful. But distributions to creditors, particularly in 13s, we're focusing on 13s, and distributions to creditors are low in many of these cases, so the costs of objecting in any individual case may not serve an economic purpose, even though allowing these improper claims on an aggregate basis may negatively impact the bankruptcy system. Second, we question whether Midland's reliance on structural protections of the Chapter 13 trustee makes sense. Trustees, and you heard Kara nod to some of these challenges in her talk. Trustees face challenges that may negatively impact their ability to police these claims. For example, volume may be an issue. Trustees may have large numbers of active cases with even larger numbers of claims, which may make case-by-case review for statute of limitations defenses impracticable, especially when you factor in other issues, choice of law issues, tolling issues, revival issues, and information to which trustees may not have ready access. So these issues about the capacity of trustees to police time-barred debt speak to a next phase, or the next phase of our ongoing research. We're in the midst of a study that looks at how Chapter 13 trustees engage in claim review and objection. We know that there is regional variation in Chapter 13 trustee practice. We are aware that claim review and objection procedures may be different from district to district, or even among trustees within the same district. So we'd like to get a sense of how varied that landscape is, how some of these factors might affect claim examination and review procedures. So as bankruptcy participants are still trying to figure out how to absorb this regulatory burden of policing time-barred debt claims, we're also interested in a phase of our research in exploring possible public law solutions which could address this practice system-wide. The courts and the U.S. trustee program, among others, do seem to anticipate that a rule change or a law change would be necessary to curb this practice. And we discussed that further in our paper. I'd like to talk a little bit more today about regulating the aggregate harm caused by stale debt claims filers through the CFPB rulemaking process. An article authored by Professor Pardo and Professor Catherine Watts, it's called The Structural Exceptionalism of Bankruptcy Administration. That article highlights that bankruptcy lacks an administrative agency with substantive rulemaking powers to set bankruptcy policy. And we're not suggesting that the CFPB take on that role. But we are wondering whether the Bureau's authority under the Dodd-Frank Act is broad enough to permit it to promulgate a rule that targets the business practice of filing stale debt claims as an unfair, deceptive, or abusive act or practice, commonly known as UDAPs, right? So putting aside the political feasibility of that right now, let's talk about how that might work. So the Bureau has authority to ban UDAPs through its rulemaking process, right? And if it were to do this, the UDAP rule would target the bigger picture. And let me explain what I mean by that. Debtors so far have been unable to obtain private remedies through the FDCPA, through Rule 911, Section 105, that would have reached these entities that file stale debt claims as a business strategy. And case-by-case review only reaches a claim within an individual case. A UDAP rule could reach the practice of using the bankruptcy system to profit from time-barred debt, and would deter this conduct because the penalties for UDAP violations are steep. The idea here is to penalize the practice of mass filing of stale claims rather than going into an individual case. Now, there are some doctrinal hurdles to clear here, right? For example, the CFPB would have to exercise this authority in a way that is consistent with, rather than conflicts with, the bankruptcy code. And the UDAP standards would have to be broad enough to capture this conduct. The Supreme Court in Midland Funding did say that under FDCPA standards, the filing of a stale debt claim in bankruptcy is not unfair and is not misleading. And there is this question of whether the CFPB could promulgate a rule under its authority to ban UDAPs that says the practice is unfair or deceptive or abusive under those standards. But if this idea could clear some of these doctrinal hurdles, it has potential to operate in tandem with the bankruptcy system, but without disturbing the bankruptcy forum. So we're not really sure what will come out of these next phases of our research about the capacity of trustees to assume the regulatory burden of stale debt claims or the feasibility of a role for the CFPB. But in terms of access to justice, Midland Funding, in foreclosing a private remedy, left this enforcement gap, and we think that it merits consideration of some of these public law solutions to close that gap. Thank you.
Thank you, Professors Bruce and Sickler. That, I think you make the point in your paper that, if nothing else, the Midland v. Johnson funding case has vastly increased awareness of this issue, which is certainly true even if we don't have remedies at hand. And I echo the thoughts of the challenges on how to deal with this, because trustees are busy, and debtors often are not incentivized. If it's not a 100% payout case in a Chapter 13, they don't sometimes care where their money goes. They know they have to pay X amount, and whether that creditor's claim is allowed or not, the amount they have to pay is the same. And information's hard to come by, and that can be exacerbated. Information about claims, that can be exacerbated by some judges. I don't know what the split is, but there's a pretty stark split as to whether, well, let me back up. Rule 3001 has certain requirements for information to be attached or filed along with the proof of claim. And there's many judges around the country that view a failure of a creditor to include that information with the proof of claim, that failure alone is not enough to disallow the claim. So, because in the thought is 502b1 says you have to have a legal basis, a contractual or legal basis to deny a claim. And so if a creditor has a judge who won't deny claims based on failure to file the information required under 3001, creditor doesn't have to file that extra information, and then the trustee, if they have a claim with not information, the trustee really doesn't know whether it's a stale claim, and then would have an additional burden of whether to take discovery. And I certainly can't speak for trustees everywhere, but trustees taking a lot of out-of-court discovery, I just don't think happens often. I'm sure it does on a case-by-case basis, but have you run into trustees that, or have you discussed that with trustees about how often they go out of court for discovery?
Okay, I'll take this one. Well, I'll tell you, we are aware of that split of authority, and I think that what we hear from trustees is that these are the kinds of issues that factor into the calculus of whether a purpose would be served in objecting to the claim. I think that, too, what I hear when you frame the issue in that way is I think of rule change, is where I head when we frame it in that way. I think that sounds like something that calls more for rule change. What do you think?
I definitely agree. It's a difficult problem to solve, and I think trustees going out and doing discovery to augment inadequate claims that are filed from the get-go is not an adequate solution. But when we see the recent changes to the procedural rules to help with proofs of claim filing, we see the Rules Advisory Committee starting to embrace more sticks to go along with it. So a recognition that just saying this is the way that the rules should work is not enough. You actually need a sanction for misconduct or when it doesn't occur. So yeah, as we see the rules developing in this area, I think an attention to the way that you police them is important to continue.
And it does seem like the way Congress moves, a rule change, perhaps like we discussed before the conference under 3001, some of those items under Rule 3001, there's consequences built into the rule for failure to comply. Not all of them, but perhaps something along those lines could be faster to come into play.
Precisely.
And another risk we talked about before that I've seen in my court, and there's other cases in the country, but if you have these stale claims, a complementary risk is that a trustee will start paying, in a Chapter 13 case, trustee will start paying on a confirmed plan, and then later somebody discovers, because the information wasn't readily available or someone just didn't notice it, or the debtor was not incentivized, I mean, any of the variety of reasons, but later it comes to fruition that somebody realizes it's a stale claim, files an objection, but the trustee's already started to make payments. So then you give rise to a state law. Almost every state, I think, has revival statutes, where then you give rise to a pretty good argument that, well, the trustees somebody has made voluntary payments on this debt, the statute of limitations is now gone.
Yeah, I think that's a huge problem. And, there's a narrative in the FDCPA cases that debtors, for the reasons you articulated, are not really harmed by the practice of filing stale debt claims. But when we see that issue of revival, and we also see it with some of the Consumer Bankruptcy Project's research on fail rates of Chapter 13 plans, that's a great example of how debtors really can be affirmatively harmed by the filing of stale debt claims, by making payments on them, and then by having their cases dismissed, and then, oh, here's this debt.
And that argument may be even stronger in state court, where there's just a lot of times a lot less familiarity with how the bankruptcy process works.
Yeah.
And I could speak to the trustee perspective on that. I can say that we have, in connection with our ongoing research, heard from at least one trustee, maybe two, about revival as a new strategy being asserted by these creditors, and one trustee just posed it as a query. What am I supposed to do that? That's another challenge I have to deal with. So it's on our radar screen in connection with our ongoing research. Trustees are starting to see, as the strategy is becoming employed with greater frequency, it's on their radar screen, so it's on ours, and we're hearing about it.
Well, it'll certainly be interesting to see where this goes. It's a timely and interesting topic.
Again, I want to echo a thanks to the panelists for coming and presenting your excellent ideas that you have and coming all the way to Atlanta to talk to us today. So one final round of applause.